Judiciary Committee. As we always do, we have all the bills with public testimony available. We have sign-up sheets up front here. If you want to sign up to be heard on one of the bills, please come sign up so we can call upon you. As it's noted, House Bill 1358, we're not taking testimony on that bill today. We'll get to that in a minute. I'll ask Senator Kennedy if you want to open us up in a word of prayer. I always like to surprise somebody. It's more genuine that way.
Please bow with me. Heavenly Father, thank you for yet another day that you've given us to do the work of the people. Please give us guidance and judgment as we go through this process. We humbly ask for that from you. And please bless all our leaders and also those in our country that have experienced loss in the last few days because of weather events. And we also pray for our world leaders. In Christ's name, amen.
Thank you, Senator Kennedy. Anybody else that want to sign up to be heard on the bill, come on up. We'll collect the sign-up sheets. Is Chairman Ballinger in the room somewhere? I think another House committee's still meeting. Is our judge of the year for the Senate Judiciary Committee present again today? Okay. Judge Burt Guy, if you'll stand up for us. Help me stall for a minute. Hey, welcome back. In the Brunswick Circuit down in St. Mary's. Thank you for joining us again and helping us out this year. All right, we are going to start with House Bill 478. Representative Rich, if you want to come on up. It's the second one on the agenda. If you'll give us just a second, because of how I don't follow the agenda, it makes it hard on our committee members to flip to the correct bills, but at least you're number 2 on here. And I'm showing LC 441884S. Is that what you have?
Yes, it is.
All right. Tell us about House Bill 478.
All right. Thank you, Mr. Chairman. House Bill 478 updates the Georgia Rules of Evidence to require the same standard for admitting expert testimony in criminal cases as is used in civil cases. This change is supported by all of the stakeholders in the legal community, including the Georgia Association of Criminal Defense Lawyers, the Prosecuting Attorneys Council, the Georgia Trial Lawyers Association, and the National Association of Defense Lawyers. A little bit of background on this. Since 1993, federal courts, including those in Georgia, have used in both civil and criminal cases the standard set forth in the United States Supreme Court case of Daubert versus Merrill Dow. This case sets the trial judge up as the gatekeeper and provides a non-exhaustive list of factors to consider in determining the admissibility of scientific evidence and expert testimony. Some of those factors are whether the theory or technique has been tested, whether it has been peer-reviewed and published, any error rate that there may be, the existence and maintenance of standards controlling its operation, and whether it has widespread acceptance in the scientific community. Even beyond 1993, Georgia continued to use an old standard, the Harper versus State standard. That 1982 case determined for the admission of scientific evidence in both civil and criminal cases the standard that simply requires that scientific evidence reach only a verifiable stage of certainty without regard for the reliability standards of Daubert. The General Assembly took up extensive tort reform, as some of you who were here at the time, back in 2005. And as part of that, we passed 24-7-702, which applies the Daubert standard in civil cases. Unfortunately, we have continued to use the old Harper standard from 1982 in our criminal cases to this day. This has resulted in the use of unreliable scientific evidence over the years. It has been determined that this is also a safer and more sure standard of evidence. And for that reason, House Bill 478 seeks to achieve parity between the two standards in the criminal and civil cases. Because after all, we are deciding in criminal cases someone's life and liberty, and that certainly deserves a higher standard.
All right. Thank you, Representative Rich. Any questions for on House Bill 478? We have a question from Chairman Tillery, looking mighty casual today. I recognize you. Welcome to the Senate Judiciary Committee.
Thank you, Mr. Chairman. It was a long night last night, and it'll be another one tonight. So thank you for allowing me to dress casual for your committee. I will say you look quite dapper with your bow tie. Representative Rich, thank you for this bill. It makes a lot of sense to make the same standard apply in civil and criminal, particularly when the issues in criminal are so weighty. My question would be, does this at all alter the Daubert standard?
No, it does not in the least.
That's my only concern.
Thank you.
All right. Thank you. Any other questions from the committee? All right. We have up. Oh, eager. We have a few people that want to speak. All right, we have 3 people signed up to speak. We'll start with, still 3 people. We'll start with Jill Travis with Georgia Association of Criminal Defense Lawyers. Coming to speak in favor of the bill, I think. And yeah, you can sit tight.
Good afternoon. Good afternoon, Mr. Chairman.
It's on. They're both.
And-
There you go.
oh,
They're supposed. I'll turn them up a little.
And then members of the Judiciary Committee. It's an awesome day when everybody's in agreement. So I'm going to just say that everybody's in agreement, and we hope that you'll pass this bill. We so much appreciate the sponsors' work on it. Thank you.
Thank you. Any questions for Ms. Travis? Next, we have Robert Smith with the Prosecuting Attorney's Council. If he's here to sing the second verse of Kumbaya. Anybody from Prosecuting Attorney's Council want to give the thumbs up? They're in favor of the bill. There he is. Good afternoon.
Good afternoon, Mr. Chairman. I apologize. There's
You're good.
just a couple matters up here and some conversation need to be had outside. I apologize.
You're good.
I'm Robert Smith. I'm the General Counsel at the Prosecuting Attorney's Council, and I want to make sure everyone understands that the DA's Association of Georgia, as well as the Georgia Association of Solicitor Generals, that's the 2 associations of elected prosecutors in this state, support this bill, support the change for the Daubert standard, and ask for your favorable consideration of the measure.
All right. Thank you, Mr. Smith. I appreciate it.
Thank you.
And next we have Mark, is it Loudon Brown with SCHR and GACDL?
Yeah,
It's a lot of letters. How are you?
Good. How are you? Thank
Good.
you. Good afternoon, and thank you for allowing me to speak briefly today. My name is Mark Loudon Brown. I'm a senior attorney at the Southern Center for Human Rights, and alongside Jill Travis in favor of the bill. I also teach forensic evidence at the Georgia State University College of Law. I wanted to just make 2 points that I think are also worth emphasizing. This bill is procedural in nature, and this has a question that has come up before. It tells judges how to assess the admissibility evidence. It doesn't tell them whether to actually admit evidence or not. And what it does, as was asked about Daubert, is it basically makes Daubert the statute in criminal court. And thus it provides judges with more guidance on how to go about deciding whether a given piece of scientific evidence should be admitted into criminal court. As was mentioned, those Daubert factors are whether the technique is testable, whether it's been peer reviewed, whether it has an error rate, whether it's subject to standards that are defined, and whether it's been accepted in the scientific community. So in line with Daubert, in line with the federal criminal courts, and in line with all the states that have adopted the same procedure proposed by this bill, the bill better guides judges to ensure that only reliable science comes in. And second, as was noted, the civil standard currently is different from the criminal standard, but science is science. It shouldn't matter what type of litigation it's being offered in. And I want everyone to know that this disparity has been noted recently with concern by several justices of the Supreme Court of Georgia. Current Chief Justice Namias, next Chief Justice Boggs, Justice Peterson, and former Justice Blackwell have indicated in a series of concurrences in Woods versus State and in Monroe versus State that they would be opening to considering a constitutional challenge to the disparate scheme between civil and criminal court because, quote, serious questions exist as to whether the United States and Georgia constitutions permit the admission of expert testimony in criminal cases that is deemed insufficiently reliable in civil cases. And so it suggests there's an openness, an atmosphere of openness to this change as evidenced by the unanimous support that the bill enjoys. And I would ask that I'd urge you to support the bill, and I'm happy to answer any questions.
All right, thank you for being with us and offering your expertise. You do have a question from Chairman Tillery.
Hey, thank you. Thanks for being here today. Thanks for bringing your expertise to the committee. My question's on line 24, and this just goes back to the question I was originally asking Representative Rich, and I think she's right. I believe her. I just want to see if you think that changing, it looks like we've made a little change there to say that previously the expert would have applied its principles to facts which have been admitted into evidence or would be admitted. By taking that out, is that a substantive change that you have any questions or concerns about?
No, I think what this does is this models the language of Rule 702, which is the federal court statute. And this is just, I believe, a tracking that language, 702.3 and 702.4, to ensure that not just the discipline is reliable, but that the individual analyst or expert in the case actually reliably applied the discipline. So I think that's, I think that was the reason for behind that change.
So the fact of whether or not those facts would later on be admitted doesn't cause any issue for you?
Correct.
Okay.
Are there any other questions in the committee? Thank you.
Thank you very much.
There's no one else signed to speak on the bill. What's the pleasure of the committee? Senator Kirkpatrick?
Move to pass.
We have a motion to pass. We have a second by Senator Cowsert. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously. Who's going to carry the bill in the Senate? Senator Kennedy. All right.
Wait, no, you are.
I am.
Yes, yes.
All right. Senator Parent it is. All right. I was only going to take one today, so I'll take this one. How about that? All right. You can have it back. You want it back?
No.
Okay. Not that it's not a great bill. Do you mind if I take Chairwoman Ballinger next? I know you have a couple other bills, but take your time. I know you ran over. Come on up.
Trust me, it won't take me very long to present this bill at all.
Well, let me update the committee on one thing while you're getting settled. She's first going to present House Bill 1234. Before we get to that, one thing I forgot to mention, House Bill 371 that was on the agenda as a substitute is coming off the agenda. That'll be heard either Monday or Tuesday. We'll work a little bit more on that language on that bill. So if you're here for 371, that will not be heard today. Now, you have two bills on the agenda. Let's start with House Bill 1234, and give us 1 second to locate it because you're kind of middle of the stack. We're working off LC 480531. If you'll just give us 1 second. All right. If you'll tell us about House, it is LC 480531.
Thank you.
That's passed the House. All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. It's an honor to be before you today. I present for your examination House Bill 1234. Basically, this allows for the pertinent parts are on lines 9 and 10. This is specifically for children who are receiving benefits past the age of 18. If somebody signs themselves out of DFACS custody at 18, they're tired, they don't want to see or hear from DFACS again, and then 6 months later they sign themselves back in. This just ensures that they get legal representation for that process moving forward. I'll be happy to answer any questions.
All right, any questions for Chairwoman Ballinger on House Bill 1234? All right, we have a couple people that want to be heard on the bill. Matt Wostowski, you want to come up with DHS Legislative Director? How are you?
Very good. Thank you, Mr. Chairman.
Good.
Thank you, committee. I'm Matt Wasatowski. I'm Legislative Director with
Wasatowski.
DHS, and this is agency legislation, and we are fully in support of the bill.
All right, any questions from the committee? All right, thank you.
Thank you, Mr. Chairman.
And the last person is Carson Cook with the Barton Child and Policy Center. Ms. Cook?
Thank you, Chairman and Committee. My name is Carson Cook. I'm speaking on behalf of the Barton Child Law and Policy Center. The Barton Center works to promote and protect the legal rights and interests of children who are involved in Georgia's juvenile court or child welfare system. I'll be brief. This is a simple bill that helps clarify the law and helps children receiving extended youth services as they transition into adulthood. We respectfully ask that the committee give it their favorable recommendation. Thank you.
All right, thank you. Any questions from the committee? All right, thank you. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? A motion to pass by Senator Parent and a second by Senator Watson. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously. And who's going to carry it in the Senate?
Senator Hatchett.
Senator Hatchett. All right. The next bill, I'm going to ask Senator Anavitarte to join you up here.
Okay.
You can sit tight as well.
Okay.
House Bill 1358, I made a reference earlier that we were not taking public testimony on the bill simply because we've already passed this bill out of committee. House Bill 1358, the substitute that we have is Senate Bill 319 that already passed this committee in the Senate floor, which is our constitutional carry bill, with one change to it, and that's the title of the act. This substitute adopts the same title, the John Meadows Georgia Constitutional Carry Act of 2022 that was on the House version of the bill. And Senator Anavitarte, is this the exact, I mean, what I said correct, is this the exact same version what you already presented to us and passed out of the committee with that one exception?
Yes, that's correct, Mr. Chairman, by adding the late rules chairman's name to our bill.
And I'm working off LC 490980S. All right, with that, I will entertain any motions from the committee on the substitute. We have a motion to pass by Chairman Tillery. Is there a second? Second by Senator Kennedy. Who pushed the button? Oh, Senator Parent, discussion?
Yeah, I don't understand why we're not having public testimony, because I know there are a lot of people here who would like to be heard on something that's really a very big deal.
Yeah, and it's not that we're not letting people be heard. It's just we already had a hearing in the committee on the bill. It's the exact same bill before. We also had the bill go to the Senate floor where it was debated for a long time as well. And so everyone's aware of what the bill is. It's been involved and everybody's been heard on the bill. I know that there was one long hearing that we had, plus a lot of our members had a lot of other meetings with advocates on both sides of the issue as well. And so long answer is it too, if we spend another hour or two debating something we've already debated, then we'll have to decide how many more House bills we want here too. And so this committee always takes public testimony. We never cut people off and let people be heard on the issues, but this is one we've already heard in committee.
Well, Mr. Chairman, I would just say that unfortunately we're giving live to what you just said about this committee always taking public testimony, and it is on something that people do feel incredibly strongly about. And, you know, there are an accumulation of shooting deaths every single week and day. So I would actually disagree with the statement that there has been, you know, nothing new or no new changes since we passed the bill. So I'll just leave it at that. Thank you.
Yeah, that's fair. And obviously there's no new change to the bill, but if this bill does come to Senate floor, I know you have a chance, as we do in our Senate side. We don't have rules in our debate as the House sometimes has, no offense. And so you'll get a chance to make those arguments again on the Senate floor as well. All right, with that, we have a motion to pass by committee substitute. And it's been seconded. All in favor of the motion, please raise your hand. We have 4, 5. All opposed? 2. The motion carries.
Thank you, Mr. Chairman, members of the committee.
Yeah, thank you, Madam Chair. And I believe you're going to be carrying the bill in the Senate. We'll circle back on that. I know we'll talk about that. Thank you.
Appreciate it. Thank you.
One thing I forgot to mention, Scott, remind me of, we have the Senate rules forms. After you present your bill here, if you want to grab a form, if you want to stick around and fill it out and leave it with us or just drop it by my office, we'll make sure we get that submitted for you. Thank you. All right. Let's get back on the agenda. Representative Rich, you want to come back up? Let's go ahead and hear your other bills that you have. Next one down is House Bill 1275. And give us again a second to sort through our stack. We are working off LC 441961S.
That's what I have to.
All right. Tell us about House Bill 1275.
Thank you, Mr. Chairman. This bill has been requested by the municipal court judges. They worked with the Georgia Municipal Association prior to filing the legislation to clarify provisions relating to the appointment and the removal of municipal court judges. Our code already provides that these judges shall serve for a minimum of 1 year. Lines 16 through 21 of the bill clarify that judges shall serve for a minimum of 1 year, regardless of whether there is a written contract. The date of service will be determined from the minutes of the municipal corporation if there is not a contract. However, if a vacancy occurs during the term, then the municipality can appoint someone to serve out the remainder of that term. That replacement does not have to serve for a full year, him or herself. This is clarified in lines 27 through 31. The code section that we're revising here is 36-32-2.1. This provision already provides that a municipality may remove a judge only for cause, and that the judge whose employment is being terminated is entitled to due process. There has been some confusion in recent past over what constitutes due process, so I am told. So lines 38 through 46 provide the specific steps and standards that are required for the due process. And this language was lifted from other provisions of the Georgia Code that outline the due process to which government employees are entitled. And I will stand for any questions.
One question I had, just to clarify, on line 76, actually 75 and 76, we talk about a process where you have cert reviewed by a superior court. Is the other House bill that's in our committee, I think it's House Bill 916, does it have any impact on the ability for these cases to go to superior court?
I am not familiar with House Bill 916.
Okay.
I'm so sorry that I can't speak to that.
We will ask that author when he comes to present that bill.
Okay.
Question to then.
Okay.
All right. Any questions from the committee? Do you have a question from Chairman Tillery?
Thank you again, Mr. Chairman. Can you tell us what is causing this? Is that so? After it, can you give us a little bit of that, and then my other question is: after your bill passes, can a city still terminate the employment of one of its employees, its employee being the judge, after 1 year?
Yes, and in fact, a city can still terminate the employment of a municipal court judge now, and they don't have to be they can do it during that first year of employment if necessary, if there is for cause. And I was not given the specific details. I was told, though, that there have been a couple of instances where a city terminated a municipal court judge and did not follow due process. So they just stated reasons and didn't give the opportunity for hearing that's required in typical due process proceedings. So this bill really just clarifies existing law.
Any other questions from the committee? There's no one that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Watson. Do we have a second? Second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously. Who's going to carry this bill in the House?
Thank you.
in the Senate?
This is the bill that Senator Kennedy and I discussed his carrying.
Okay.
Okay.
All right. Next on the agenda is also your bill, House Bill 1348. I think you told me all your bills are in my committee. Is that true? Or do you have others?
Yes.
Well, let's flip to House Bill 1348. We are working off a substitute, which is LC 540088S. I'm sure you'll do this, but when you present, tell us the difference in the substitute versus what passed the House too.
Yes, Mr. Chairman. Has everyone found it yet? Yes. 1348, okay. All right, this House Bill 1348 is requested by the Department of Health, and it is actually a very simple bill, as we say around here. It will update the Smoke-Free Act to bring parity to the law to treat vaping and traditional tobacco smoking the same. This issue was brought to my attention by my local health department after an issue that arose during a restaurant inspection. The current Smoke-Free Act was adopted in 2005, before vaping became as widely popular as it is. Currently, the provisions of our law that prohibit smoking in enclosed places like restaurants, schools, and daycare centers do not apply to vaping. So individuals can vape in any of these places under Georgia law. Electronic smoking devices, commonly known as vapor products, don't actually emit just harmless vapor. The industry has actually hijacked this term and to call their devices vapes and to use the term vapor, which has led to the dissemination of a dangerous fallacy. Electronic smoking devices, in fact, emit aerosol, not just vapor. And aerosols contain nanoparticles, such as nicotine and other toxins that are in the vape products. These nanoparticles are actually smaller than particles of tobacco smoke and are present in much larger concentrations, making it even more dangerous to inhale secondhand vape or aerosol. This measure will bring Georgia in line with 21 other states, including our neighbors Florida and Alabama, that prohibit e-cigarettes or electronic smoking devices in locations where traditional smoking is also prohibited. And this will help protect the health of the public and really all members of the public, but especially our most vulnerable children and individuals who are sick and have respiratory illnesses. So I will stand for any questions.
Did you mention the difference in the two versions?
Oh, yes. The difference is located on lines 50 through 53. Let's see. Let me pull out my old. So originally, line 51 originally read, vaping means the action of or practice of inhaling and exhaling vapor or aerosol from nicotine or other substances. And this has been revised. And then it went on to say such terms shall include the use of a vapor product. And it has been revised to read, vaping means the action or practice of inhaling and exhaling vapor or aerosol from nicotine or other substances from a vapor product, period. And the reason for this was to make sure that we excluded any inhalers that are prescribed for medical reasons.
All right, any questions for Representative Rich from the committee? All right, you're welcome to stay there. We have one person signed up to speak, Polly McKinney with Voices for Georgia's Children, our advocacy director.
Hi, and I'll be brief because you guys have about 400 bills on your docket, and I just want to say that we are in full support of this legislation. Happy to take any questions, but if you have real questions, you can look at the fact sheet.
There you go. There's also a fact sheet that was provided that everybody's been handed to. All right, any questions in the committee? Thank you.
Thank you.
All right, no one else signed to speak on the bill. What's the pleasure of the committee?
Do you mind if sorry, I forgot to sign.
Come on up. No, come on up.
Elizabeth Newcomb with Children's Healthcare of Atlanta, and just wanted to go on the record and say that we fully support the bill.
All right, thank you. I appreciate it. Yeah, thank you for coming up. All right, we have a motion to pass by committee substitute from Senator Parent. Is there a second? Second by Senator Watson. Any discussion? All those in favor of the motion, please raise your hand. It's unanimous. And who is going to carry this one in the Senate?
So is it Senator Mullis that is offered? Okay.
Senator Mullis. All right. Will this impact the stuff that he was out there with the Native Americans doing in the park early in session?
I don't know anything about that.
He made some speech about that one time. And okay, we'll ask him. Stuff I shouldn't say. All right. That's all you have? No other bills?
I think that's it.
Okay. Thank you. All right, let's somewhat stick on the agenda because it's the next bill in that stack. Chairwoman Cooper is here. Well, she was here. Oh, there she is. Come on up. And we're going to do House Bill 752, which is a committee substitute. 752 LC 339134S.
That's correct.
You have someone join you up here as well?
I do. You want to introduce yourself?
Mr. Chairman, my name is Nick Jurich, and I am with the State Bar of Georgia Fiduciary Law Section.
All right, thank you, Mr. Jurich.
And
All right, give us 1 second to make sure everybody has found the bill. All right, the floor is yours, Chairwoman Cooper.
Thank you very much, Mr. Chairman, and I will say I do appreciate the bar giving us excellent help in working through this. We have been working on an advanced psychiatric directory for 14 years, and we are finally at a place where we have this worked out. And you have a sheet showing all the people that are in favor of this, and I think we are missing the Georgia Hospital Association, and I am very thankful. It also gives a brief outline of what the bill's about. Basically, before my able judiciary help, I would like to say that for it's been a problem in our state and across the country, too, that we have not treated mental health issues like we treat other health issues. And so you have an advanced directive when you are, entering the last parts of your life, and you can tell people how you'd like to be treated. But this gives people who suffer from mental health issues something that can be utilized so that they can let people know, the physicians, when they are not in crisis, how they would like to be treated. And, it's sort of a guideline of, maybe some treatments they've had before and that worked and didn't work. It's very advantageous for this, especially for the emergency room physicians. But even bigger than that, the second thing is they can, when they are not in crisis, it allows them to appoint an agent to speak for them when they are in crisis and to be able to receive information from the physicians about what is going on with them and help make sure that their wishes are carried out, or if there has to be an alteration in those wishes because of availability of a kind of treatment or a place that they would like to be treated, that agent can act for them. And with that, I'm going to let an attorney, thank you for doing this for me, go through the bill, since I'm dealing with a large group of very fine attorneys on your committee.
Thank you, Chairman Cooper, and thank you to Mr. Chairman and to the committee for letting us speak. Also with me today is Dan Munster, who is an attorney, and Dan led up a task force that was created by the Fiduciary Law Section to draft this bill, or to take some of the existing bills from the last 14 years and whip it into shape, and did so with the cooperation of representatives from many of the institutions that you see listed at the bottom of that fact sheet, and he did a great job in getting them all together. 15 years ago, Representative Thunder Tumlin convened a similar effort of those interested in substituted judgment for healthcare decisions, and convened a task force that wrote the Advanced Directive for Healthcare bill, which took effect in 2007. And just a reminder, that is still in effect. It combined a power of attorney and a living will into a more modern document that allows anyone to appoint a healthcare agent to make decisions for them about their health care. And that has served us well for 15 years now. What this bill does is create a very similar form, and in fact, the language in the statute uses a lot of the language from that Advanced Directive Healthcare statute, but creates a form that is specifically intended for those who are diagnosed with a mental illness or a developmental disability or an addictive disease. And that is an important distinction, and some of the differences between the forms are because of the difference in who the form is intended for. An advanced directive for healthcare is intended for all of us. We should all, who are adults, complete an advanced directive at whatever stage of life we're in, because we never know if we're going to face a situation in which we cannot make healthcare decisions for ourselves. The psychiatric advance directive that you had in front of you, though, is not intended for all of us. It is intended primarily for those who have been diagnosed with one of the conditions I mentioned. And you'll see that in the form itself, which provides much more specific guidance than you could in your own advance directive about your health care. There are items in there where you can describe very specific treatment instructions, where you can describe the symptoms of your particular mental illness or developmental disability, where you can state who your preferred clinicians are to see you if you reach a crisis and cannot make decisions for yourself. It allows you to name particular individuals who you want to help in a situation. It even has guidance for law enforcement about how you may interact with law enforcement when you are in crisis, so that law enforcement knows what to do and not to do. That's a lot of direction that none of us could give with regard to our health care, and would be very difficult for someone to give who wasn't actually facing a mental illness or a developmental disability. But this provides them the ability to appoint someone to be their agent and to provide specific instructions for when they can't make those decisions themselves. So it's a bit of a long bill, and I won't go through it. As I said, a lot of it piggybacks on language from the Advanced Directive for Healthcare statute, which has what you might expect: authorizing the form, explaining how it is executed properly, explaining how it can be revoked, provides for standards for complying and not complying with it, provides protection from liability for healthcare institutions for complying or not complying with the directions of an agent, has protection for law enforcement for complying or not complying with the directives, which is a little unique to the Psychiatric Advance Directive compared to the Advance Directive for Healthcare. In addition, we have amended the Advanced Directive Healthcare law itself to make sure these mesh and to make it very clear that if you have an advanced directive for healthcare that appoints an agent who has the say over your physical and mental health, that if you also have a psychiatric advance directive, that it trumps your advanced directive for healthcare in matters relating to mental illness and developmental disability or addictive disease, so that if you happen to have appointed different persons, which I think would probably be unlikely in practice, but should you have done that, it will make it clear that for the mental health related matters, your mental health care, your psychiatric advance directive agent would trump the health care agent. And then it amends all the other laws that make references to advance directives for health care to make sure they also apply where it's appropriate to the psychiatric advance directive as well. So with that, happy to take questions from the committee.
But some of our doctors have questions. Dr. Kirkpatrick, you first.
Thank you very much for your presentation. My question is about starting on page 33, which is actually the form, and it's about the witness requirements. And this seems different than the witness requirements for the regular advance directive, and I just wanted to confirm that. And also, it doesn't look like the form has to be notarized, so I want to be sure that's correct.
Answer your second one first. It does not need to be notarized. That is also the case with the Advance Directive for Healthcare. The same language is in the form and in the statute. And that was debated 15 years ago when that advanced directive healthcare statute was drafted, and it was decided that a notary requirement, which of course adds a level of certainty about whether or not the declarant is doing what they say they're doing, might be more of an impediment than a help in a situation, and that having two independent witnesses was sufficient in the case of this this kind of form. And so the same decision was made for the psychiatric advance directive. On who can be witnesses, I don't have the advance directive healthcare witness or form in front of me, and I couldn't identify where they differ. And I don't know, Dan, if you are familiar. Okay. My understanding is that it was similar because the intention is to have someone that is not involved with the patient's care.
I think Dr. Tillery may know the answer. Dr. Tillery, do you want to interrupt?
I apologize.
No, I think it's, would it be true that it's the same as the Advanced Healthcare Directive? I think you have to have two witnesses who are not related.
You have to do witnesses. Can you
It's just the requirements, if I recall, were related to the healthcare team. The person who witnesses can't be anybody that's involved in your care, and then that's similar to what's in here. But the other person, if I recall, and again, I don't have it in front of me either, has to be someone who would not benefit from your death.
From your death.
Yeah.
So that is in the advanced directive for healthcare, where the witness can't benefit from your death. And the reason for that is that in the advanced directive for healthcare, there is a provision of that allows an agent to make end-of-life decisions. And the form provides specific instructions for end-of-life decisions, the withdrawing of life-sustaining treatment. That's not in the psychiatric advance directive. I'm not a doctor, so I won't say there's never a situation in which the decision to apply or not apply certain treatment in a mental health care setting would directly lead to death. But that's the reason why that element is not in the psychiatric advance directive witness list. Yeah, it was cannot be a person. You can't be your agent, can't be involved in your care, and I'm not seeing the one that you were mentioning.
Tillery, Senator Tillery. Were you?
Oh, I'm sorry. I'm looking at the psychiatric advance directive. I have. I thought this was the advance directive for healthcare. No, I think Senator Tiller. I think you're exactly right, and that's the reason for this.
And there's two on the Advanced Healthcare Directive, and
there are two witnesses required for an advance directive for healthcare.
And then last thing, since it doesn't have to be notarized, I guess it doesn't have to be remote notarized either, correct?
Not yet.
Not yet.
Senator Kirkpatrick,
still be unclear
those your
if
questions?
it can be electronically executed. We'll get to that next year.
Dr. Watson.
Thank you, Chairman. Could I point you to line 611 on the form there? It talks about additional interventions, and it says, I prefer the following interventions. The word prefer is what I'm trying to point out. And then if you circle back to lines 590, when you're talking about treatment facilities, initially in 585 I prefer, but then it goes down to line 590. It says I refuse to be treated at the following facilities. And sort of the same logic on 520.